Hi, my name is Robert Chelle with Chelle Law, and I'm an attorney that assists physicians with employment contract and independent contractor agreement issues. Today I'm going to talk about W-2 versus 1099 for a physician. So what are the key differences between the two, and then what are some red flags, particularly if you're going to sign an independent contractor agreement. So as a W-2, you are an employee. At the end of the year, you'll receive a W-2. Taxes will be taken out of any of your compensation. And so you are essentially characterized as a full-time employee. Now, there are some part-time situations where you'd be an employee as well. But for this discussion, let's just say that you're full-time. Things that you'll get as a employee that you won't get as a 1099 independent contractor: benefits. So health, vision, dental, life, disability, retirement. They should pay for your license, DEA, CME. They'll likely provide your malpractice, maybe tail if you have a claims-made policy, maybe not. So the main difference is: one, taxes are taken out; two, usually some kind of exclusive relationship, or at least you would have to get their approval if you wanted to work elsewhere. And then you'll also get benefits, as I said. So as a 1099 independent contractor, at the end of the year, you'll get a 1099, and no taxes are taken out of your compensation throughout the year. Most 1099s get no benefits at all, and that's kind of one of the key factors of whether you're a 1099 or a W-2, or at least one of the factors. Maybe the organization that you're working for will provide your malpractice insurance, but that's usually the extent of it. Everything else you'd be responsible for covering. So why would someone be a 1099 versus a W-2? Well, as a 1099, it's kind of meant to be more for, I guess, part-time employment. So maybe you're filling in once a week or a few times a month. The schedule is kind of completely up to you when you want to go in. Now, obviously, as a physician, it can't just be, hey, I'm coming in tomorrow. There needs to be some planning, but for the most part, it's not exclusive. You're allowed to work elsewhere. There probably shouldn't be any kind of restrictive covenants in it either. No non-compete, maybe a non-solicit, something like that. But it should be easy to get into and easy to get out of. And what I mean by that is the notice required to terminate the 1099 independent contractor agreement will likely be less than an employment agreement. Normally, I would suggest around 30 days for an independent contractor agreement, whereas the standard employment agreement would be 60 to 90 days. And so what are the benefits or disadvantages of both? One of the main problems that I see pretty frequently is when an organization dictates to the physician, this is what you're going to be. You're going to be an independent contractor, but that all of their duties, responsibilities, all kind of lean towards them being an employee. The IRS lists a 20-factor test, and then you can kind of go point by point, and then it'll kind of determine what you are. And so it's, some of the factors would be: do you have control over your schedule? Do you have control over the patients that you're going to see? How much resources do you use? Are you using their office and their employees and their EMR and their admin? If you're working completely full-time for an organization and they're dictating all of those things, it's very likely you are not truly an independent contractor. So why would someone misclassify an employee as an independent contractor? Most of the times to get out of having to pay employment tax. Employment tax varies state to state, but somewhere between 8 to 12% is normal. And so I find many times an owner will just simply not want to have to pay the employment tax. So they just tell the individual, you're going to be an independent contractor, when nearly everything about their job is the duties of an employee. And then they also will say, all right, you're an independent contractor, so we're not going to give you any benefits either. And you're going to be responsible to pay for CME and your associations and societies and all that. type of thing. For whatever reason, like derm, anesthesia, pretty common that they would be independent contractors when even if their kind of actual duties are not. So what is the absolute red flag for that situation? Well, the IRS or the state could come in and do an audit and look at your contract and look at your duties and determine that you are not an actual independent contractor, you are an employee, and so you've been misclassified, and so they are going to reclassify you. And in that situation, there could be back taxes, there could be fines, there could be penalties. And so sometimes you'll see language in an independent contractor agreement that basically shifts the entire burden for a misclassification onto the physician. Absolutely cannot agree to that or sign a document with that. You shouldn't be responsible for fines and penalties and back taxes when you weren't likely the one that even made the decision for you to be an independent contractor. There needs to be language that actually is the opposite, that if there is a misclassification, then the employer or organization, whatever you want to characterize them as, will be the ones responsible for paying the back taxes and the fines and the penalties and the attorney's fees and that type of thing. So be very careful about signing any contract where you are completely responsible for any kind of reclassification issues. All right, that's a little bit about being a W-2 versus 1099 as a physician. If you have any questions about an employment contract or independent contractor agreement, feel free to contact my law firm at the information listed below in the description. All right, thank you for watching the video. Take care.